Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I am going to be your employment lawyer for the next half an hour, answering all of your questions about all things employment law. As you can see, I'm an associate at Samfiru Tumarkin, LLP, which is Canada's leading employee side employment law firm. Okay, great. Missed you guys all in the last session. I wasn't here, but happy to answer all of your questions today. So without further ado, let's get into them. We've got Anne asking, can an employer make you repay paid time off days if they had previously approved them and paid them? I don't really understand the question. Did you take more time than you were entitled to, and they want that money repaid? It's not uncommon when there's a termination that happens, and more vacation time has been taken by the terminated employee than that employee accrued to date, that the employer will claw back some of that some or all of that paid vacation time out of the severance, be it mandatory ESA, Employment Standards Act severance, or common law severance, to claw some of that back or all of it back. I've certainly seen that many times. But I mean, it depends on what you're entitled to and why they're trying to claw it back. So I would need more information before I can properly answer your question. It may be from your question that you're asking, they approved a certain amount of paid time off, and then they said, we don't like this policy anymore. We're going to roll it back. If that's the case, I mean, yeah, probably. Constructive dismissals, your only option if your employer changes a fundamental term of your employment is to trigger your constructive dismissal. That's it. That's the entire set of options that you have. Pardon me for the noise outside. That's the entire set of options that you have. Sorry, I'm going to plug in my headset because that's very loud outside. I don't know if you can hear it or not, but I'll plug it in anyway just to make sure we're sort of clear as possible. Can everybody hear me? So, as I was saying, your only option in a situation where your employer changes a fundamental term of your employment is to trigger your constructive dismissal. What that simply means is the actions of your employer have effectively repudiated the employment contract such that you no longer work for the employer, and so effectively their actions have de facto terminated you. And that only makes sense if the amount of severance that you have coming to you is substantial. But even so, constructive dismissals are hard to make out because you have to get a court to agree that, yes, the actions of the employer were in fact a termination. And so to get there, the change has to be fundamental. And so, if you had 8 sick days and now you have 6, you might not like it, but you're not going to be able to get constructive dismissal. So you effectively have no recourse. And so your solution, and if that's what your question is, which I'm not sure, your solution is to reach some sort of amicable arrangement with your employer, and I know your employer might not want to play ball in that one. So unfortunately, there may be very little you can do in that circumstance. Okay, question from Chris: can your employer force you to not wear a mask at work? I have not heard that one before. I have a respiratory condition and would like the added safety of wearing a mask, but my employer said that we're not allowed. Chris, the answer to this one is very, very simple. Go get a doctor's note. Have the doctor's note say, yes, Chris is medically required to wear a mask at work. You give the doctor's note to your employer. You do it by email, and you can hand it in person. But just as a general for everybody who has a medical issue affecting their employment, if you have to provide a doctor's note to your employer, provide it by email from your personal email so that you have a record of it. Or if you're going to send it from your work email, make sure that you save a copy of that email so that you have a record that it was sent. You don't want to be in a situation after the fact where you're trying to prove that, in fact, you did provide the doctor's note, okay, on a certain day. So yeah, get the doctor's note, hand it to your employer, do it by email. You can also do it in person, but make sure you have a paper trail of it. And I don't think that's going to be an issue. If it is an issue going forward, you have a human rights complaint, and then you have to assess, is it worth it for you to bring a human rights complaint, because you're probably going to poison the well with your employer. Well, it's not just a human rights complaint, it's also an occupational health and safety issue, because your safety is at risk if you have this respiratory condition. So I expect the doctor's note to solve the problem. Your employer is not going to be happy about it, but I expect that your employer will toe the line. If your employer doesn't, you should talk to an employment lawyer right away and assess what your options are, because at that point, I think that if your employer refuses to let you wear a mask, even though you have a medical condition backed by a medical note, I think that's absolutely a constructive dismissal. I think you have a human rights claim as well, and so you may wish to pull the trigger on all of that. Now you won't have a job there anymore, but you will have severance coming to you. But that only makes sense if contractually you have common law severance coming to you, and then you have a decent amount of severance based on your age and your length of service and position coming to you. Although, I mean, if this is a non-starter for you, you might have to go anyway, right? But Chris, yes, Chris, 100% you need to talk to an employment lawyer. It's very complicated. Your situation is very, very complicated. The easy part is, the doctor's note, but it's what happens next that you might need to talk to an employment lawyer about your situation if your employer doesn't play ball with the doctor's note, although I expect it will. And these things tend to move really fast. So certainly after you hand in the doctor's note, you're going to want to talk to an employment lawyer if the answer you get is not the one you wanted. And again, as always, if you need to reach us, I unfortunately did not bring my materials today, but it is help at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900, I believe. Yeah, I think that's correct. And it is, as you can see on the screen. So if you want to get a hold of us, you can do it right there. But certainly, Chris, you need to talk to an employment lawyer if after you hand a medical note in, your employer still insists that you can't wear a mask. Do union workers, this is from Bubba, do union workers get severance pay? So I don't practice in the area of we'll say union side employees. Generally speaking, your rights flow from your collective bargaining agreement. There is also legislation that interacts with your collective bargaining agreement, we'll say, or that your collective bargaining agreement is subject to. Certainly that, I'm not very familiar with that, but generally speaking, my understanding is your remedies are reinstatement rather than money, although I've seen it happen before with union workers where they get paid severance. I don't really know very much about that area, so I'm not going to answer more than that. I'll just encourage you to speak to your union representative. Your union representative will be able to assist you with that question. Okay. JR, what is the best method for a prospective employee to define his or her terms of employment? Is it through initiating an email correspondence with the HR department? I don't understand the question, JR. The thing that defines the terms of your employment are the terms of your employment, right? Like, are you trying to figure out what your terms are? So the core terms of your employment are you go to work for a certain amount of hours to do a certain amount of duties in exchange for a certain amount of pay. That's it. That's the core of your employment, your contract of employment. Now, your employer can choose to take, and there are ancillary terms sort of built around that, but those are the core terms that live in the air between the two of you. And there are ancillary terms that you guys probably agree on, but that aren't necessarily written down, but your employer can choose to write some of those down to bind you in an employment contract that you agree to and sign, okay, provided it's backed by fresh consideration. Now, when you ask to define the terms of your employment, that employment contract, the written one, is going to do that, okay? If you have no employment contract, that is to your advantage and you shouldn't ask for one. Okay, I mean, almost every situation, unless you're a very high income earner or someone with a lot of leverage within the four corners of your employment, it is to your advantage to not have an employment contract, and don't insist on one. Okay, because if you don't have an employment contract, upon termination, you automatically get the common law for your severance, which is quite lucrative. And any other terms with respect to any other pieces of your ancillary pieces of your compensation will be interpreted effectively against the employer because these terms aren't clear at all. I mean, the limits your employer may try to impose upon those terms aren't written down and aren't agreed to. So I hope that answered your question. But like I said, the core terms of your employment, you're exchanging labor for money indefinitely. And you may have some additional terms written down in an employment contract, and that will define sort of the four corners of what the terms of your employment are. But should you initiate an email correspondence with HR to find out? No. Now, if this is a question of my job description says X, Y, Z, and now you're asking me to do, F, which is totally different, I would be... People get a lot of times, clients of mine will get caught up in job descriptions. Okay, job descriptions aren't really anything. I mean, they help you outline the four corners of what your employment is. But if you're a janitor, okay, you're a janitor, and your employer, and your duties consist of cleaning the hallways, cleaning the bathrooms, etc. And then your employer says, well, you've also got to clean the break room, and that's not in your job description. Does that mean your employer can't tell you that? Of course not. If your employer says go clean the break room, that's within the four corners of what your job as a janitor is, and so you've got to go clean the break room. Just because it's not in your job description doesn't mean you don't have to do it. Okay, but if you were a customer service manager in a call center and they told you to go clean the break room, yes, that's not in your job description. Do you have to do it? Probably not, because it's not rationally connected to the four corners of your duties. If you don't do it, they might fire you, but they're not going to be able to fire you for just cause by paying you zero. Okay, and whereas if in the janitor situation, if they said, "Hey, do this, go clean the break room," and janitor said no, that's insubordination, and it would be. The employer could fire the janitor for just cause and pay that janitor zero because he or she didn't do something that was rationally connected to the four corners of his job or her job. Okay, I hope that answered your question. Juanita asks, my company was bought about a year ago. The new owner wants to lower my wage. Can they do that? I've not signed any new contracts or anything. So if your employer unilaterally imposes new terms upon you that you reject, you have effectively triggered your constructive termination. I'll back up to what I said earlier, Juanita. Your only recourse here is to trigger your termination. Okay, you either have to accept what they've done or trigger your termination. Now, you have 2 months to try on the lowered wage, after which time you're deemed to have accepted it. Although when it's just a lowered wage and nothing else changes, that amount of time that the court wants you to try on or gives you to try on the test out the lower wage before you can choose to reject it is shorter. Say 4 weeks kind of thing, because it's lower pay. You either can or can't work under the lower pay. So you've got to decide fairly quickly if you want to pull the trigger on your constructive termination, and that's going to be dependent on how much severance you're entitled to. If you're entitled to 4 weeks of severance, then you may not want to do that. But if you're entitled to 24 months of severance, you absolutely might want to do that. And it also depends on how much the wage is being lowered. If your wage is being lowered by 7%, it might not be a constructive dismissal. But if it's being lowered by 25%, that's absolutely a constructive dismissal. The other thing you got to think about here, Juanita, is the new employers. So I don't know if it was an asset purchase or a share purchase, and I don't know if your previous length of service was carried over into the new company or not. Generally speaking, certainly in BC, if basically there was no change in your employment and the employer didn't announce to you clearly that it was not carrying over your previous years of service, then you're probably fine. But this matters in terms of what your overall severance entitlement is, dependent upon what's in your employment contract. So if all of that sounds really complicated, Juanita, that's because it is. Your question is inherently very complicated. And so you absolutely should talk to an employment lawyer. You should not make any decisions but without talking to an employment lawyer, getting legal advice. And you got to do that now. You got to do it quickly because, well, let me qualify that. Your employer actually hasn't done anything yet. It says that it wants to lower your wage, but it actually hasn't done so yet. So, it may in fact do that. But, do you need to talk to an employment lawyer right yet? Not necessarily. But if your employment lawyer lowers your wage today, you got to talk to an employment lawyer, I'd say the following week. Okay, you got to move quickly on that because you have about 4 weeks to test out whether or not you want to work under this lower wage, and after which you're going to be deemed to have accepted. You can't 4 months from now say, you know what, I don't agree with that pay cut. Well, each province is different. That's the case in BC. I know Ontario is a lot more flexible about that timeline, but certainly the Supreme Court of Canada in its famous case called the Potter decision, it was 8 weeks, I think, in that case. So, you don't have a ton of time, but very complicated. So if you need to speak to us, Juanita, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, and you can call us at 1-855-821-5900. Okay. Oh, JR is back. Should one initiate the terms of employment via email, outline the desired employment guidelines? JR, I think I answered this question fully before. I don't think you should do that at all. I don't really know what you're getting at, so you may want to speak to an employment lawyer because I don't really understand what your question is and what you're trying to achieve. But generally speaking, if your employer hasn't made you sign an employment contract, that's a win for you. Don't bring it to their attention. Okay, Rosalind asks for a friend. She says her friend resigned a job due to being stalked by someone from a neighboring company. She tried to distance and even called 911. She resigned due to her concerns about her safety. Should she tell her interviewers this when they asked her the reason why she resigned? Would this be a red flag to tell? I don't understand. So if she works in an office environment and there's several businesses in the building, or let's just say on the same floor in the building, and someone from an ancillary business, and that's a different business, starts threatening her safety, I mean, at that point, it's incumbent upon her to tell her employer, hey, this is going on. Can you assist me in trying to resolve this? Then the employer would talk to that business to try to put a stop to it. It's her election to resign. Does she have any recourse against her employer? Well, it depends what her employer did and if she disclosed what was happening to her employer. Should she tell her exit interviewers why she resigned? I don't. Why would this be a red flag for who? For what? I don't understand the question. I would certainly say, like, listen, I like it here, but my safety is being threatened, and here's why. But I also don't know, honestly, I don't understand the particulars of your question because this is very complicated. Is she tried to go to the police? Is that what you said? I don't know if her safety is an issue. If her safety continues to be an issue, she should call the police immediately. I don't, Rosalind, I don't really know what you're asking. I don't understand if is your friend trying to protect her reputation? Does she want to get compensation from her company? I don't understand. So maybe if you could clarify for us. Sam asks, sorry, hold on. Oh, this is for a new job. Okay, so Rosalind is saying if she applies for new jobs and they ask, well, what happened to the old job? Yeah, listen, first of all, it's not really an employment law question. It's an assessment of how you think that interview is going to go. And if you say to the interviewer, I resigned because I felt like I was being stalked by somebody in a neighboring office, Is that going to throw up a red flag? Depends on the interviewer. There are lots of interviewers who would take great sympathy with that based on their lived experiences, and there's others who would think, well, this might be a red flag. Let's not look. Even though they can't from a human rights perspective, they would do it anyway. Let's keep looking. So that's really a question your friend is going to have to assess. It's not an employment law question. It's can I? Well, I mean, it's an employment law question to the extent that she can't be discriminated against for it, we'll say, in the hiring process. But how do you prove that? So I think that's a question she's got to think about and answer herself about whether or not she wants to disclose it. Generally speaking, I think that employers have many candidates and they're assessing you for, depending on the position, obviously, because it is a historically tight labor market right now. But they're assessing you for, for long-term fit and generally speaking, you don't want to put anything that might resemble a red flag on their plate. That's the way I have historically approached interviews. Why complicate it? But that's just a question. I can't answer that question for you. You'll have to assess it, and that's also an interview by interview assessment. Where you might get a good vibe in an interview and think, well, this is something I should disclose. But I mean, really, that's about something else. That happened in the past. You don't expect that to happen in the future. So, not sure if why you're sort of bringing it up in an interview, but that's a decision you have to make. So. And I wish your friend really good luck with all that. And again, I will say that if her safety is an issue, that she should call the police immediately. Sam, okay, returning to Sam. If your employer fires you for refusing to do something that isn't connected to your job, is that a wrongful termination? Well, wrongful termination just simply means that your employer fired you without paying you the amount of severance you're due and owed at law. Okay, so that's what wrongful dismissal means. But the question is, can your employer fire you? And I actually answered this question earlier in the janitor example. Can your employer fire you and pay you zero, right, for your insubordination? Now, it depends on how rationally connected the thing you refused to do was to your job. Right. So again, if you're a customer service manager in a call center and they ask you to clean the toilets, yeah, you can refuse that. It's not going to be just cause. But if you are the janitor and they ask you to clean the break room and that wasn't in your initial job description and you say no, that could be just cause. Now, generally speaking, a single instance of insubordination is just refusal to do what your employer asks you to do. A single instance of insubordination is not going to land you. It's not going to be enough to trigger just cause termination, generally speaking, but it could be, and it especially depends on, just cause is a contextual analysis. So if you've been there for 20 years and have a clean disciplinary sheet, that's totally different than if you've been there for one and have 3 write-ups for lateness and other things, right? So, but generally speaking, one's not going to get you there. But Sam, to answer your question, it depends how closely connected. You say it's not connected to your job. Well, I mean, it depends on the degree, right? And so if they've fired you and offered you severance, well, actually, let me rephrase that. If you've been fired for the reason that you said, you should talk to an employment lawyer right away. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. As you can see on the screen now. You should talk to an employment lawyer right away to find out if you've got entitlements, basically. But it's going to come down to the level of connection between what they asked you to do and your job generally. Okay, Anita asks, if you leave your job because of a medical condition, are you owed any sort of compensation? No. Short answer is no. I mean, your employer owes you compensation. Well, let me rephrase that. From a severance perspective, no. If you quit, you don't have any entitlement to severance. However, if your medical issue happened on the job, you'd be entitled to occupational health and safety compensation. In BC, it's WorkSafe BC, income wage replacement to a certain extent. Or if it happened, and I don't do any disability work, although our firm certainly does a ton of it. It does a lot of it. But if the injury happened to you before your last day, and you have long-term disability and you qualify for it, it may be that, or short-term disability, I guess, that you can go on disability and get compensation that way. So you should, Anita, if that fits for you, you should absolutely do that, or potentially go on disability, or you can contact us. I don't have the disability numbers for the disability wing of our firm handy. Maybe the moderator does, but you can certainly contact us and for some advice on there you go, disabilityrights.ca. You can find out more there, but about if you should claim disability and how you go about doing that. So Tara asks, I'm worried about some upcoming meetings that I must have. When am I allowed to record these meetings at my workplace? So secret recordings are interesting. They are somehow they're admissible in court. So if you, I can't remember the exact terminology, but if you go to a meeting, you're worried you might get fired in the meeting, and you secretly record it on your phone, what was said, that actually can be evidence in court later because you consented to it and you were one of the parties to the conversation. I believe that's what the law says. I've often wondered how that could be, but I think that's correct. And certainly, phone recorded meetings are evidence in employment law cases all the time. There was a case, and the name escapes me now, a couple of years ago, where the employee recorded every meeting that he had with his employer, and that was actually successfully deployed, we'll say, not to confuse terms, successfully deployed by the employer as evidence that the relationship between the employee and the employer was irreparable, and was fundamentally impaired such they had just cause to terminate his employment, and they won. So, I think in that case, it was like 50 recordings or something like that. So be careful with that. One, yes. Constantly, probably not. You're welcome, JR. Oh, JR, one more question. What is the best way to define pretense that can lead to employee monitoring red flags? I don't understand the question. Is your employer? You're saying your employer is creating reasons to monitor you? Is that what you're saying? I don't know what you're getting at with that particular question, but it sounds like the relationship between you and your employer is starting to get a little bit frayed. I don't know the particulars of your situation. I don't know if you've been there for 25 years. I don't know what your education level is. I don't know what your prospects of changing jobs to a different employer are. But if you said yes, that okay. So listen, if they're creating reasons to monitor you, then it sounds like your relationship with your employer is, for whatever reason, is starting to go downhill, right? Now, it is always an option for every employee that if they feel that their employment is not moving in the direction they want, they can vote with their feet. They can always look for another job quietly while still getting a paycheck at their current employer and then move on. Now, obviously, it's a lot easier depending on your age, right? So if you're 35, sure, that's not a problem. If you're 62, very hard to get hired somewhere else, a new job at 62.
Right? Employers tend to not want to take on employers north of 60 or even 55, even though refusing to do so is a human rights issue. It is a historically tight labor market right now, and so a lot of employees who are not happy with their employers are choosing to vote with their feet and go work somewhere else. In terms of monitoring you, your employer can monitor you to a degree that, as long as it doesn't infringe upon reasonable privacy rights, I mean, I think the great example is those keystroke monitors where software is installed in computers to record what you're doing, and if you're, on Facebook or something like that, your employer, um, your employer will know, and for that kind of thing, are they permitted to do that? Yeah, they are. Legally, that's not going to get you to constructive dismissal. Would I work in such an environment? No, I wouldn't. I would vote with my feet, and certainly that's, I think a lot of employers are probably finding that out as they try to install that kind of software. So, if they're monitoring you, is there anything you can do about it? No. From my evaluation, it sounds like if they're doing that already, the relationship is probably in trouble, and um, unless you can salvage it, it may be something that you may want to start looking around to do something else. Now, I obviously, JR, I don't know anything about your situation. Could be in a small town, could be the only game in town, and what I'm saying is not helpful in that regard if that's the case. But if they're monitoring you and you don't like it, you're either gonna have to start looking around for something else, or take steps now to fix the relationship with your employer. And certainly, if you need to talk to an employment lawyer about that, you can. Although it's not really a legal issue, but with that, I'll leave it. I'll leave you with our contact information if you need to get a hold of us, and then I'll wish everybody a good day. So you can always get a hold of us at employmentlawyer.ca, help at employmentlawyer.ca, or 1-855-821-5900. As always, I am Dan Balkaran. I will be here in 2 weeks, returning for my regular Friday 10:30 Pacific time slot. You can join us, I suspect, on Monday with Chris Justice, but it might not be. But I suspect someone's coming up. And it's Madalena, fantastic. Tuesday, May 16th, Madalena Vixney. She's going to be answering all your questions. Employment law. Madalena is very, very, very good at employment law. So come join us for that, and listen to all of her wisdom about all things employment law. But other than that, I wish you guys a wonderful and safe weekend. Thank you for the wonderful, great questions. Until next time, thank you.